Welcome, everyone. Today we're diving into the connection between law and ethics in business. It's not just about what's legal, but also about what's right. Laws set the minimum standard for behavior, but ethics ask more of us. Think of it like this. Just because you can doesn't mean you should. For example, it's legal for a company to lay off workers before the holidays to cut costs, but is it ethical? Would it be fair if the CEO received a large bonus during that same quarter? Ethics challenges us to go beyond compliance and consider impact. And this chapter sets the foundation for understanding the relationship between law, ethics, and business decisions. A core theme today is that ethical business isn't just good for the soul, it's increasingly critical for long-term success. And so as we go through today, keep this tension in mind and think about how you would navigate it in your career. The intersection of law and ethics in business presents complex challenges for decision makers. While laws establish minimum standards of conduct, ethical considerations often demand more. This tension between the legal requirements and moral obligation forms the foundation of responsible business practice. In today's business environment, corporations wield significant economic power. Companies like Shell, ExxonMobil, Walmart, Apple, and even BP each generate more income than entire countries such as Belgium, Switzerland, Norway, and Russia. This economic influence raises important questions about corporate responsibility to various stakeholders. Other things to consider might be, what about political contributions? Do large corporations have too much power? What about large-scale advertising and the power of corporations to sway public opinion? Another issue for discussion or thought would involve the duty of large multinational corporations to citizens of countries in which they operate. For example, if corporations are reaping large profits because of the availability of cheap labor in third world countries, should the corporations recognize a duty to improve conditions? Or should corporations recognize the duty only to the stockholders? What does it mean to humanize capitalism? How can multinational corporations avoid exploiting people, communities, and the environment? What about the need for adequate safety measures and environmental protection, even in countries where laws on such matters might be lax? So, let's start with the hypothetical. If you're walking down the street and saw an infant lying face down in a puddle of water, flailing its little arms and clearly about to drown, would you have to rescue her? You might be surprised and probably even disgusted to learn that bystanders have no legal duty to help others in emergency situations, even when it would be easy for them to do so without risk. Notice, though, that there's a divergence between law and ethics, between what is required by the law and what most people would think is the right thing to do. And this leads us into one of the themes of this chapter, and really even the whole book: individual freedom versus duty to others. Individual independence versus our interdependence within families, corporations, and communities. Why is the legal requirement so minimal? Now, as you think about this, it's important to understand traditional distinction between misfeasance and nonfeasance. Misfeasance involves doing an act that is legally permissible, but doing it in a way that causes harm or injury. Examples of this would be a doctor performing a surgery negligently, a contractor building a house poorly, or a government official mismanaging funds. While misfeasance can involve negligence, it's not always intentional wrongdoing. It's more about failing to act with reasonable care or skill. Misfeasance is a concept primarily found in tort law, which deals with civil wrongdoings. Nonfeasance is the complete omission or failure to perform a legal duty and results in harm. Examples of nonfeasance include a landowner failing to warn invitees of a dangerous situation or condition, a lifeguard failing to rescue a swimmer in distress, or a doctor failing to diagnose a condition. Nonfeasance can be due to negligence or even intentional disregard of a duty. Now, this is also a concept that's primarily found in tort law. So let's review some key differences here. When we're talking about action, misfeasance is the improper performance of a lawful act, while nonfeasance is failure to act when there's a legal duty to act. Intent, misfeasance can be negligent or intentional, and that's the same for nonfeasance. When we're looking at it from the perspective of harm, misfeasance is caused by the improper performance of the act, while nonfeasance is caused by failure to act. Examples again of the two might be misfeasance, negligent, surgery, poor construction. Nonfeasance might be failing to warn of danger, not rescuing a swimmer. This leads us to the next section. Now, we have to address the idea of no duty to rescue. So this no duty to rescue rule states that in most jurisdictions, bystanders have no legal duty to help others when there's an emergency situation, even when it would be easy to do so without risk. Now, this rule also highlights the divergence between legal requirements and ethical expectations, revealing tensions between individual freedom and responsibility to others. There are exceptions to the rule: special relationships, contractual obligations, and situations where one has created the danger might create a legal duty to rescue. Now, we're going to look at a couple of cases throughout this chapter. First, I want to unpack the Yania case. This is a dramatic and a tragic situation here. Some key facts are Joseph Yania visited John Bigen's coal strip mining operation in Pennsylvania. Bigen, the landowner, allegedly urged, enticed, and induced Yania to jump into a water-filled trench. Yania did jump in the trench and he drowned. Bigen made no attempt to rescue him. He just watches. Yania's widow sued Bigen for negligence. In the court ruling, the Supreme Court of Pennsylvania ruled that Bigen had no legal duty to rescue Yania. The court stated, the mere fact that Bigen saw Yania in a position of peril in the water imposed upon him no legal, although moral, obligation or duty to go to his rescue. The court determined that while Bigen's conduct might have been morally reprehensible, there was no legal requirement to aid someone who voluntarily placed themselves in danger. The court rules no legal duty to rescue. Sounds cold, right? Now, I want to talk a little bit about the legal significance of this case. This case reinforced the common law principle that there's generally no duty to rescue strangers. It does distinguish between moral and legal obligations, and it highlighted the doctrine that nonfeasance, failure act, is treated differently than misfeasance or harmful action. Legally, the principle is clear. There's often no obligation to help unless a special relationship exists. But ethically, that's where the discomfort creeps in. What would you do? What if it were a child or your classmate? This case illustrates a fundamental tension between individual freedom and social responsibility. While the law prioritizes maximum free choice and personal autonomy, ethical considerations often suggest a duty to care for others in our interdependent communities. This case challenges us to think about freedom versus responsibility. In business, we often face similar choices. Do we speak up about wrongdoing? Do we help a struggling colleague? Ethics ask us to lean into our shared humanity. Let's look at another case. In this case, Judge Perillo elaborates on several exceptions to the no duty rule. If an individual has a pre-existing legal duty to render assistance, that duty impels him to act for which omission he might be liable. Now, in New Jersey, courts have recognized that an existing contractual relationship between victim and one in a position to provide aid might create a duty to render assistance. For example, in Sabo versus Pennsylvania Railroad, the court held that the employer must secure medical care for an injured employee rendered helpless while engaged in work for that employer. It might only be necessary to find some definite relationship between the parties of such a character that social policy justifies the imposition of a duty to act. A general duty arises in many relations to take reasonable precautions for others' safety. That might include obligation to exercise control over the conduct of third persons with dangerous propensities. Now, in this case, the state's hit-and-run driver state statute imposes a duty of the driver to stay on the scene regardless of fault. Drivers are also required to report all accidents involving injuries to the nearest police department. In this case, here are some key facts. Michael Podias was killed in a bicycle accident in November 2007. His roommates, including Ryan Mayers, found his body hours later. They made multiple cell phone calls but never called 911. The roommates moved the body and the bicycle to make it appear Podias was hit by a vehicle. Podias' father sued the roommates for negligence. Now, you're probably wondering how the court ruled on this. New Jersey Appellate Court allowed the case to proceed, found potential in their special relationship between the roommates, creating that duty to summon help. The judge actually applied a 4-factor test for establishing liability. Foreseeability and severity to harm is 1, 2, opportunity and ability to prevent harm, 3, relationships between parties, 4, public party considerations. And we're going to talk more about this in a moment. But first, I want to review the legal significance of this case. This case expanded potential exceptions to the no-duty rescue rule, recognized that close relationships might create legal duties, connected the opportunity and the ability to help with legal responsibility, and it showed the evolution of duty to rescue doctrine in modern context. I want to expand out and talk a little bit more about the 4 factors and also how they related to this case. Now, 4 factors is the nature underlying risk of harm. That is foreseeability and severity. The judge noted that the risk of harm, even the death to the helpless victim lying in the middle of the road, was readily and clearly foreseeable. The opportunity and ability to prevent harm. All 3 individuals used their cell phones for purposes other than reporting the accident. They had the opportunity and ability to take simple precautions to save that victim at little, if any, cost or inconvenience to themselves. The comparative interest and the relationship between or among the parties. The judge found that the defendants were more than innocent bystanders or strangers due to their relationship to the primary wrongdoer. He was giving them a ride home, as well as the incident. Ultimately, based on considerations of public policy and fairness, the societal interest in the proposed solution, the judge determined that the imposition of a duty upon defendants was in accord with public policy, citing New Jersey laws that promote rescue. According to the textbook, a change in our law, a new duty to rescue, might change the way people think. It might heighten their awareness of one another as members of a community and lead them to be more responsive to one another. Do you think law can have such power? Can you think of any examples where a change in the law seemed to improve the moral climate of our society? In Law, Morals, and Rescue, Anthony Honoro argues that law cannot make men good, but it can, in the sphere of duty at least, encourage and help them to do good. I want to read an excerpt from The Good Samaritan and the Law by Ratcliffe. It's a little bit older. It was published in 1966. Here's what it states. An essential preliminary to the survey of larger vistas of law and morals is clear to our minds about our moral views in the matter of aid to those in peril. By our moral views, I mean the shared or common morality. Obviously, this is not the same as the statement of what people actually do in a given society, the common practice of mankind. Their actions may fall short of their moral ideals and pretensions. Nor is it the same as that which an individual might accept for himself as morally obligatory. There is a distinction between that which an individual accepts for himself and that which he regards as being of general application. A man may think he has higher ideals, a stricter sense of obligation or duty, than the ordinary run of men could well be expected to entertain. This cherished personal morality, it seems to me, is no part or ingredient of the shared morality, though it may come in time to spread to others and do so to influence the shared morality. The shared morality consists rather of those moral ideals and duties or obligations which the bulk of the community regard as applying to persons. There are strong reasons, I think, why the law should reflect, reinforce, and specify at least that segment of the shared morality which consists of moral duties owed to others. The first is the advantage to those who stand to benefit. It's true, legal incentives probably influence no more than a tiny minority, but they certainly influence some. Secondly, there are some reasons for holding that the law ought, in general, to mirror moral obligations. In doing so, it ministers to an expectation entertained by the majority of citizens. People, to some degree, expect a lead from the law, not merely threats and incentives. Rules of law which mirror moral duties have, among other things, an educative function. They formulate in a way which, though not fallible, is yet in a sense authoritative, the content of the shared morality. So, in listening to that and thinking about where you are, where do you think the line should be drawn on bystander liability? This next section will familiarize you with different ethical theories often used to aid in the decision-making process. But first, think about this. Assume you're the chief CEO of a large drug company. You're deciding what price to charge for a new drug that promises to be effective against lung cancer. Assume that insurers would be willing to pay a large price for the drug and that some uninsured members of society could afford to purchase the drug. Now, some uninsured people would simply be unable to purchase it as well. How should you go about deciding how much to charge for the drug and whether to offer it at a lower price to some members of society? Ethical decision-making and ethical analysis is a complex process, and it may not yield definitive outcomes. But these frameworks provide valuable tools for navigating difficult decisions. Your textbook states, ethical analysis, unlike much quantitative analysis, can be a messy, complex business without a clear and definitive outcome. However, we do have tools at our disposal to help us make these complicated assessments. So let's explore the 4 ethical lenses with real-world relevance. The first in the toolkit is free market ethics. Milton Friedman said, "The business of business is business. Maximize shareholder profit and obey the law. CSR, or corporate social responsibility, that's someone else's job." Now, Milton Friedman is a well-known free market economist and supporter of that view. Under the free market view, the primary responsibility of a corporation is to improve the value of the investment of shareholders while obeying the law. Decisions regarding society should be made in the political arena and funded by tax dollars. Friedman strongly voiced that view in 1970 when he stated, "In a free society, there is one and only one social responsibility of business: to use its resources and engage in activities designed to increase its profits, so long as it stays with the rules of the game, which is to say, engages in open and free competition without deception or fraud." An example of this would be a CEO decides to outsource to cut costs, even if it devastates the local community. The second component in that decision-making toolkit is utilitarianism. Jeremy Bentham and John Stuart Mill promoted the idea of maximizing overall good. Under utilitarianism, the consequences of an act to all those affected by it are considered. A proponent of that theory would try to determine the alternative likely to produce the greatest overall good to all those who would be affected by the decision. An example of this would be a company closes one factory to save 5 others and thousands of jobs. The few suffer, but the many benefit. The third component in this decision-making toolkit is deontology by Kant. Right and wrong are based on duty and universal principles. Deontology is the name given to an entire area of ethical theories based on steadfastness to universal principles. The most famous deontological thinker, Immanuel Kant, stated that these principles may be derived through categorical imperatives, one of which states that individuals should be willing to have the reasons for their actions become universal principles. Steadfast adherence to the 10 Commandments could also be discussed as an example. Under deontological ethics, other people should not be used merely as a means to achieve a purpose with no mutual benefit attached. An example of this might be, you tell the truth to a customer even if it means losing the sale. The fourth component in this toolkit is virtual ethics, or ethic of care. And this focuses on who we are, not just what we do. Virtue ethics focuses on what human beings are capable of being and on how they can cultivate habits of good character that will naturally lead them to their fullest potential. Virtual ethics focuses on moral characteristics ingrained within a community. For businesses, this is often found in the values statements and corporate culture. BP's corporate culture is discussed later in the case study in this topic, but their corporate culture really displayed in the oil spill their virtue ethics. What would corporate culture or community be for the hypothetical drug company of that had the drug to cure lung cancer? Here's an example of this concept. A business mentor helps a struggling intern, not out of obligation, but out of compassion and character. So why ethical theory? Why is that important? Awareness of the theories provides support in 2 ways when facing business dilemmas. The decision maker is better able to think broadly and deeply when brainstorming using multiple frameworks. And 2, the decision maker is better able to understand his or her own thinking and articulate it to others. Today's complex world presents a challenge to the virtue ethics approach. Individuals are exposed to many different communities that may have very different values. How is virtue defined? How is integrity maintained? These questions may be especially hard to answer when the values of different communities do not align. In the hypothetical, consider the company's ethics, alongside the ethical values ingrained in the physicians who worked for the company as it created this new drug. This slide gives you some external resources on ethical theories. You can also do your own research to see how ethical theories have been applied to business. I do want to say that this would be a great slide to save and refer back to for your final research project. I will also include a document that gives you this example. This is just a platform to get you started, by no means an exhaustive list here on ethical theories. A corporation is a machine made of people. So let's break down the roles here. Shareholders, own shares, but often don't participate in those day-to-day activities. Owners whose legal liability is limited by law to their investment in the company. They have right to receive accurate financial reports, dividends when they're declared, attend shareholder meetings, vote on some issues, and hold managers and directors accountable via the shareholder derivative suits. The board of directors make big strategic decisions and hire and fire executives. They're elected by shareholders and held by law to a duty of loyalty and care towards the corporation. The board sets overall policy, provides financial information to shareholders, hires and fires management, and also may file lawsuits on behalf of the corporation. Officers and management handle operations, CEO, CFO, etc. They're appointed by the board and held to the same duty of loyalty and care. They run the company, they implement board decisions, and they prepare reports. This layered system is meant to create accountability, but when communication breaks down or incentives are misaligned, ethical lapses occur. Think of Enron, where the board failed to stop fraud, or Theranos, where management misled investors and patients. So ask yourself, who should be held responsible when things go wrong? Let's look at another case here before we dig into corporations, public policy, and money. In 2010, the Citizens United versus the FEC. So the Supreme Court ruled that political spending is protected speech under the First Amendment, and the government cannot restrict political expenditures or expenditures by corporations, associations, or labor unions. There were two dividing positions here that really did divide the nation. Justice Stevens' dissent was that corporations are not people. They may contain potentially disparate opinions, and they might be controlled by non-citizens who cannot vote. However, on the other side, Justice Kennedy stated that political speech is crucial to democracy and should not be suppressed. Corporations might possess valuable expertise, and their voices should reach the public. They argued that political speech is the most important and most protected speech that exists. And it is, in fact, crucial to the democratic process that political speech be encouraged and heard. The arguments that the immense wealth of a corporation might distort the messages heard by the citizens are not enough to suppress that political speech. This case highlights the distinction between whether a corporation, which is considered an entity much like humans, and whether the corporation has all the rights of such. Here's a summary of the two opposing views that really did divide the nation. I want to discuss another case before we move on regarding corporations, public policy, and money. Many of you might be familiar with the Burwell versus Hobby Lobby case. Some key facts there was that Hobby Lobby, as you know, arts and crafts retail chain, objected to providing certain contraceptives in health insurance. The company owners cited religious objections based on their Christian beliefs. Now, the Affordable Health Care Act required employers to provide contraceptive coverage. Hobby Lobby sought exemption based on the Religious Freedom Restoration Act. The court ruled 5-4 in favor of Hobby Lobby. It held that closely held for-profit corporations can claim religious exemptions. It found that requiring contraceptive coverage substantially burdened religious exercise. And it also determined that the government could achieve goals through less restrictive means. This case has pretty significant legal ramifications. It extended religious freedom protections to certain for-profit corporations, and it further developed the corporate personhood or human aspect of a corporation with religious dimensions. It definitely created tensions between corporate rights and employee benefits. But it also raised questions about balancing religious freedom with healthcare access. This case raised fundamental questions about corporate personhood that we are still talking about today. It also invites some pretty big questions like, should your employer's beliefs limit your healthcare choices? Since corporations are treated as individual entities in many respects, should that entitle them to all the rights that are granted to the people? Should corporations have the same rights as people? What rights should they have? Corporate social responsibility, or CSR, asks, who matters in business decisions? The traditional view is that shareholders only. In the CSR view, all stakeholders, employees, customers, environment. CSR suggests that businesses should consider all stakeholder interests, not just the shareholders. While this is not a new concept, it does remain controversial. Milton Friedman viewed it as inappropriate for profit-focused companies, while others questioned its effectiveness. Market forces supporting CSR include consumer preferences for socially responsible companies and the growth of socially responsible investing. Here's an example. Unilever commits to sustainable sourcing. Why? It's good ethics and also smart branding. Opponents like Friedman say CSR is vague and distracts from accountability. Supporters say consumers and employees increasingly demand it. Would you rather work for a company that values ethics or one that values only profit? Why? Benefit corporations are a legal response to CSR's limits. They embed ethics into the company charter. More than 2,200 companies across more than 50 countries have joined the benefit or B Corporation movement, which redefines what business success means and redirects that power of business. B corporations focus on the triple bottom line: profit, people, and planet. Now, I mentioned that there are over 2,200 B Corps that have been certified or that are out there. They are certified by what's called B Lab, and you can find more information about that on the website www.bcorporation.net. This is a good place for you to do some research and explore companies and what's involved to become certified, what kinds of companies are there. Something to look into as you put together your final project paper. A growing number of consumers prefer to make purchases from socially responsible companies. Additionally, the socially responsible investing, or SRI, movement has to represent approximately $8.7 trillion in 2016. SRI investors work to have corporations change behaviors and make targeted investments in socially responsible companies. Features of that B Corporation is that they have a legal obligation to consider people and planet. They have transparent reporting. They have protection from shareholder lawsuits for prioritizing their purpose. Here's an example of a company that is a B Corporation. Patagonia reinvests profits in conservation. Their legal structure protects their mission. So let me ask you, should more companies be required to consider social environment impact? What trade-offs might that involve? Let's compare the differences between traditional corporations and benefit corporations. Traditional corporations are going to be profit-focused with fiduciary duty to those stockholders. Their responsibility is to earn as much profit as possible to those stockholders. A benefit corporation, outlining that triple bottom line concept, that profit, people, planet, they can go into a certification, that B Corp certification, and that's that third-party verification on that website I mentioned in the last slide of social and economic performance. The BP Deepwater Horizon oil spill, I briefly mentioned it at the beginning of the presentation, but I want to talk a little bit more about this. For those of you who just know the basics of this, I want to recap that, or if you've never heard about the Deepwater Horizon oil spill, just bring you up to speed as we talk about corporate social responsibility. So in 2010, there was an explosion in the Gulf on the Deepwater Horizon drilling rig. 11 workers were killed, 17 were injured. At that time, approximately 4.9 million barrels of oil spilled in over 87 days. This was the largest accidental marine oil spill in history. And as a side note, it's still leaking. Last time I checked, it had leaked over 12 million barrels of oil and was ongoing for many, many years. There were a lot of investigations then that revealed safety failures, some cost-cutting decisions that could have contributed to this problem, to this disaster. There were so many legal consequences, but just to summarize this, BP pled guilty to 14 criminal counts, including manslaughter and Clean Water Act violations. They paid $4 billion in criminal penalties, $20.8 billion civil settlement with federal and state governments, and total cost exceeded $65 billion. Also, there were multiple corporate officers that faced criminal charges. Now, they happily paid that, and they were able to stay in business because of the amount of money that they make in the oil industry. So it was a little bit more than a slap on the wrist, but also didn't destroy them. Now, there's long-term impact here when we talk about CSR, that corporate social responsibility. It did reform offshore drilling regulations and safety requirements. It changed corporate risk management approaches in the oil industry as a whole. It established new environmental monitoring systems in the Gulf, and it led to organizational restructuring at BP. It created a precedent for corporate criminal liability in environmental cases. Suppose you could revise the law of rescue. Would you hold people responsible for doing something to help others in an emergency? If so, what circumstances would trigger a duty to rescue? How much would be required of that rescuer? Consider a few things. Whether laws should be rewritten to require rescue attempts. You might also think about what is an emergency calling for rescue? What constitutes a rescue? What if the rescue inadvertently worsens the situation? Who should rescue? How much should a rescuer be required to do? For example, call 911 versus actively attempt to rescue the person? Should compensation be allowed to a rescuer who is injured? I want to go back to our theory here for a minute and bring that into this particular case study. In the utilitarianism theory, we discussed that it was the consequences of an act to all those affected by it are considered. The proponent of that theory would try to determine the alternative likely to produce the overall good to those who would be affected by the decision. So in the BP example, in which shareholders, workers, coastal residents, fish, other creatures, the ecosystem, and the public at large are all considered, in the hypothetical, all affected would be considered. That would include stockholders of the company, individuals, employees of the company, insurers. The same really could be applied to the drug company that we talked about. The BP oil spill demonstrates the difficulty in utilitarian analysis of determining consequences, both good and bad, that can be traced to a complex scenario. Comparing BP's decision on the backup switch with its decision to participate in deepwater drilling in the Gulf illustrates a chief criticism of the utilitarianism. The theory will accept harm, even severe harm, to a small number of stakeholders as long as there's an overall benefit to the majority. Maybe we have our own oil. We don't have to buy it from other countries. Now remember that deontology theory was the name given to the entire area of ethical theories based on the steadfastness to universal principles. Under deontological ethics, other people should not be used merely as a means to achieve that purpose with no mutual benefit. In the BP oil spill, several deontology principles were violated. The hypothetical might address the confusion that's created with deontology when different universal rights and duties crop up in the same ethical problem and seem to conflict with one another. I guess at the end of the day, when thinking about the BP oil spill, it just goes back to, did it serve the greater good at the end of the day, considering we still have leakage even today going on from that disaster? What are your thoughts? Now, let's bring this full circle with some tough realities here. Every year, $100 million is spent in lobbying. So are lawmakers listening to voters or donors? 1,900 times CEO pay. 1,900 times regular pay. What does that say about fairness to those employees and workers who are out on the rigs risking their lives? In the BP oil spill example, a disaster from cost cutting, the disaster came from cost cutting and ignoring the risk. Also, AstroTurf lobbying, which is fake grassroots groups funded by big business. It's legal, but is it deceptive? Business ethics isn't abstract. It affects workers, communities, and the planet. Your values will guide how you lead and what kind of legacy you leave. My final thought here is that law gives us the framework. Ethics gives us the soul. As future leaders, you'll face choices where their legal and ethical lines blur. The question isn't just what can you do, it's what should you do. And that answer may define your impact on the world. As we've explored throughout this presentation, the intersection of law, ethics, and business presents complex challenges that require thoughtful analysis. By understanding legal frameworks, applying ethical decision-making tools, and considering the broader impacts of business decisions, organizations can navigate these challenges while creating sustainable value for others. The key takeaways from this chapter are the legal versus the ethical framework. Legal compliance is necessary, but not necessarily sufficient for ethical business conduct. There are multiple frameworks out there, and different ethical theories provide valuable perspectives for decision making. Corporate power. With great economic influence comes increased responsibility. And stakeholder value. Sustainable business considers impact beyond shareholder returns.